This meeting of the Senate Judiciary Committee will come to order. It's my understanding that Senator Graham is on the way and has asked us to start. We'll, of course, recognize him when he arrives for any opening statement he may have. Last week, I went to the Senate floor and paid tribute to a fallen Chicago police officer, Andre Vasquez Lasso, 32 years old. He was an immigrant to this country, became a U.S. citizen, volunteered for the Chicago Police Department, and served there for 5 years. He was killed protecting the same Southwest Side neighborhood he lived in. On March 1st, Officer Vasquez Lasso responded to a 9/11 call about a domestic violence incident. When he arrived on the scene, the suspect fled and a chase ensued. The suspect had a gun, and when he ran into an elementary school playground with children present, he turned and fired it 5 times. Kids were taking cover under slides and equipment they could find on the playground. Officer Vasquez Lasso was killed. For his funeral last week at St. Rita's Chapel, his wife Milena wrote, and I quote, "I wish I would have hugged you stronger that Wednesday morning, given you more goodbye kisses. If only I had known it was the last time I would see you alive." Every day, millions of Americans, like Officer Vasquez Lasso, dedicate themselves to protecting public safety and keeping our communities and our kids safe. Law enforcement officers, emergency responders, social service workers, community leaders, and teachers. These are increasingly dangerous jobs, in part because there are more guns than people in this country, and hundreds of Americans are shot every day. We owe it to these Americans to enact laws that will help protect them from being shot and killed. I believe that well-regulated firearm ownership to keep America safe is consistent with the Second Amendment. But we're up against a gun lobby that wants to strike down the gun laws on the books and stop new ones from passing. And that brings us to the Bruen case. Here's a brief video.
For more than a century. But the ruling tonight impacts not only New York, but 7 other densely populated states with similar laws where 80 million Americans live.
Shocking. Absolutely shocking.
In addition, the court established a new test for determining whether gun legislation is constitutional.
The old test had history in it, but it also considered contemporary costs and benefits. What the new test apparently does is say no consideration of contemporary costs and benefits, only history.
What the Supreme Court said, what Justice Clarence Thomas said is, you can't balance the individual right against public safety, against protecting against violence and crime. You can only look at, quote, history and tradition. The NRA and other gun rights advocates are going to be able to go into court and challenge hundreds of gun laws that have been upheld by the courts.
A federal judge in Texas has ruled it's no longer constitutional to ban people under felony indictment for buying guns.
Appeals court ruled yesterday that the government can't stop people who have domestic violence restraining orders against them from owning guns.
The bottom line, a lot of gun laws on a lot of jurisdictions could now be vulnerable with this new standard that the Supreme Court has come up with.
For the record, the Bruen decision came down the day before the Dobbs decision, which of course drew a lot of public attention. The gun lobby got what it wanted in the 2008 Heller case, a Supreme Court decision making clear that the Second Amendment is an individual right. But the gun lobby wasn't happy with more than 1,500 cases that implemented Heller in the lower courts. Why? Because those cases largely upheld the gun laws on the books from constitutional challenge. The courts said those laws passed muster under Heller's then 2-step test that looked both at history and considered modern day ends and means. That was just too much for the gun lobby to take. So they went to work. They advocated aggressively to put justices on the Supreme Court who supported a history-based approach to Second Amendment challenges, so-called originalism, literalism. I discussed this approach with both Justice Kavanaugh and Justice Barrett at their confirmation hearings. because I was concerned about what a conservative majority on the Supreme Court would do to our gun laws. And then, as I feared, the gun lobby worked to get a case before the Supreme Court, the Bruen case. Last year, the court's majority went further than necessary to decide the case and established a new, purely historical test for considering the constitutionality of gun laws. The gun lobby was thrilled. Wayne LaPierre of the National Rifle Association put out a press release. He called the Bruen decision a landmark win for the NRA that, quote, unequivocally validates the position of the NRA. That's the same Wayne LaPierre who sat in this room 10 years ago and testified before this committee that we, quote, need to enforce the thousands of gun laws that are currently on the books. But his Bruen press release didn't say that. It said, quote, many unconstitutional gun control laws remain in America. The NRA will continue to fight these laws. Now, after the Bruen decision, long-standing gun laws on the books are being challenged across the country, more than 100 cases so far. And under the new Bruen historical test, judges decide not whether a law reasonably protects public safety, but whether the law resembles laws that were in place in 1791 or in 1868. In the beginning, in 1791, of course, we were talking about muzzle-loading muskets. I think about drawing that standard, legality and constitutionality based on 1791. And I think about last 4th of July in Highland Park, Illinois, when a deranged individual went on the roof of a downtown business and discharged 83 rounds in 60 seconds, killing 7 innocent people and injuring dozens of others, including paralyzing an 8-year-old little boy, Cooper Roberts. So it's no surprise to see decisions like the Fifth Circuit's recent Rahimi case. A panel of judges struck down a federal law barring those with domestic violence restraining orders from possessing guns. I can't square that decision with the actual danger that women and police officers face from armed domestic abusers. And I don't believe the founders of this nation would have wanted courts to simply ignore this danger when applying the Constitution they wrote. The chaos that the Bruen decision has caused was predictable. For 15 years, courts have been steadily applying the Heller decision to make reasoned judgments about gun laws on the books. Now, the Supreme Court has imposed a radical new framework under Judge Thomas's decision with barely any guidance to apply it, and plenty of opportunity for judges to cherry pick from history to engage in judicial activism in the name of originalism. The gun lobby saw Bruen as a landmark win, but it's a significant challenge for police, law enforcement, and the population of America when it comes to public safety. That's what we'll discuss today. We have a distinguished panel of witnesses that will examine where we go as we navigate Bruen's unprecedented upheaval of efforts to combat gun violence. I look forward to this discussion. I now turn to the ranking member, Senator Graham.